Hello and welcome back, my law lovers, to another episode of Lawyer Up. I'm your host, Cami Lynn, and here on this channel, we dive deep into the latest legal issues facing some of your favorite celebrities. Now, just a friendly reminder, the information that we share here is only for entertainment purposes only. It is not meant to be considered, it's not intended to be considered legal advice. So if you need legal advice, please contact an attorney. All right, guys. Where do we start today? Okay, so for today's case, my lighting just did a backflip almost. All right, guys. For today's case, we are going to talk about someone who is not necessarily a celebrity, but they've been thrown into the spotlight, so she might as well be one. This is a big case, guys. It's a big case. All right, so today we're going to talk about none other than our girl down in ATL, Atlanta, Fani Willis, in this hearing that's coming up in terms of whether or not she is going to be disqualified from the Trump RICO case. All right, so a little background, guys. Michael Roman, who is a co-defendant with Trump, has filed a motion to have Fani disqualified for basically conflict of interest and showing that she benefited from the relationship with her. At one time, it was speculative. It was just rumored lover, Nathan Wade. But now it is no longer speculative. Fani has confirmed that she and Nathan did have a romantic relationship. Okay. So again, Michael, he files this motion to have her dismissed from the case. Fani, in turn, responds to that filing. She's asking for this hearing to be dismissed, but the judge denied her request for dismissal, and rightfully so, because he stated in the hearing I think it was yesterday, that they need to have on record what her response is, or what the response is, I should say, in terms of the relationship. And they need to get down to the bottom of whether or not she benefited from this relationship. So what does that mean? Get down to the bottom of it, blah, blah, blah. Okay, let's talk about this. Let me just add before I go into that. Fani was subpoenaed to testify in the hearing. This actually scheduled for Thursday and Friday. Now, whether or not that occurs is still up in the air in terms of whether or not she actually testifies, but she has been subpoenaed to testify in that hearing. Okay, let's get back to why is this important? What is the issue here? So the issue is whether Fani Willis somehow benefited from this relationship when she hired Nathan Wade. And at question is, when did this relationship start? Now, here's why it's important. It's important because if she hired Nathan Wade after she started working on this case, and there had, this relationship actually blossomed after, the relationship in terms of romantic interest blossomed after she hired him, then maybe that's a little bit different, and maybe she didn't necessarily benefit from it, not necessarily. But the question is, when did she start the relationship? And there is various discrepancies in terms of when this relationship started. Okay, so Fani, in an affidavit, stated that the relationship started in 2022. Now, the defense is saying that's incorrect. They are saying that this relationship started prior to this Trump case, and that the relationship actually started in 21. They are they're going to subpoena one of a co-counsels at Nathan Wade's previous firm that he worked at, that will basically testify that the relationship started prior to the Trump case. So that doesn't look good. The other issue is that in Nathan's divorce interrogation or deposition, He stated that he was asked whether or not he had been in a romantic relationship during the course of his marriage, and he stated no. And this was in May 2023. Now, again, in this affidavit that Fanny filed just February 2nd, she said this relationship started in 2022. Nathan has since then he's gone back and he has corrected his statement for the within the divorce filings. So it's just really a mess, and it's looking like amateur hour, just complete amateur hour. I don't know why Fanny would have allowed herself to be really this victim of salacious, romance, regardless of whether or not he's married or not. It's just being dating or banging your co-counsel and this coming out. She should have known that the defendants were going to they were going to uncover every stone there was to find out what they could on this prosecutor. Now, keep in mind, she's not dealing with Joe Schmo, the defendant. You're dealing with the former president of the United States. So to me, she should not have hired Nathan. She should have been smarter about it, but she did. Okay. So what I want to do is I want you guys to hear what the judge, what he said about whether or not there is some sort of grounds for potential disqualification. And it sounds like the judge is saying there is. Okay, let me switch over. I'm just, this part always gets so confusing as I'm changing layouts just so I can do. Okay, here we go. Now I'm going to move this back to the 5-minute mark so you guys can hear the judge. And then we'll talk a little bit about Michael Roman's attorney, who happens to be a former Trump campaign official. So again, they're uncovering every stone they can on this prosecutor, on Fani. Okay, let's get started. Let's see what the judge has to say. We're going to start at the 5-minute mark.
We shouldn't have a evidentiary hearing at all, and that quashal is appropriate on those grounds. So to that end, and studying the law that's been filed up to this point, I think it's clear that disqualification can occur if evidence is produced demonstrating an actual conflict or the appearance of one.
All right, did you guys catch that? So the judge said that he thinks it's clear, and again, please hear him out. He thinks it's clear that disqualification can occur if evidence is produced that demonstrates that there is an actual conflict here, conflict of interest, actually that goes against the professional rules of conduct for attorneys, or an appearance. This is even if there was not an actual conflict, an appearance of a conflict of interest. So please note that.
And the filings submitted on this issue so far have presented a conflict in the evidence that can't be resolved.
And I think this is telling. He said the filings submitted on this issue so far have presented a conflict in the evidence that can't be resolved. I think there you have it there. Whether it's an actual conflict or an appearance of a conflict, he's saying the filings that have been submitted so far, they do present a conflict in the evidence. And what's important is that it can't be resolved. Now, what does that, if you're getting your psychic globe out, you're foreseeing the future, what do you guys think what do you guys think is going to happen to Fani here? I think this sounds like disqualification. I mean, obviously I'm being presumptuous because I don't know how this hearing is going to proceed. I don't know what evidence is going to come out, but just based on what I'm hearing so far and what's been submitted, and again, he's saying that a conflict of interest here in terms of the evidence that can't be resolved does not look good for Fani Willis. Okay, let's proceed.
As a matter of law, specifically looking at defendant Roman's motion, it alleges a personal relationship that resulted in a financial benefit to the district attorney, and that is
personal relationship that resulted in a financial benefit to the DA and that it's no longer a matter of speculation.
No longer a matter of complete speculation. The state has admitted a relationship existed.
Yep, Fanny, she came out, said, well, she really couldn't deny it. She came out, said that the relationship does exist, and so it's no longer speculation from the defendant. It is confirmed.
And so what remains to be proven is the existence and extent of any financial benefit. Again, if there even was one.
All right, so was there a financial benefit? What's the extent of that? And again, this goes back to what I said earlier. Was it taking her to dinner? Did they buy plane tickets to get? Did they go on vacation? Did he pay for it? I don't know. Did he buy her some expensive jewelry, bracelet, necklace? I don't know. Anything that's expensive that she may have benefited from based on the salary that he made working with the state, then it would appear that she benefited from this relationship.
So, because I think it's possible that the facts alleged by the defendant could result in disqualification, I think an evidentiary hearing must occur.
Did you guys catch that? He said because of an appearance that it could appear that she benefited from the relationship. He thinks that an evidentiary hearing has to occur to establish the record of the court allegations. And I just want to add, this is why her motion to dismiss was denied, for this very reason, because it does need to go on record what the nature of the relationship is or was, and when did it start. They're going to dig a little deeper into this. This does not look good for Fani, guys.
Establish the record on those core allegations. So just to emphasize, I think the issues at point here are whether a relationship existed, whether that relationship was romantic or non-romantic in nature, when it formed, and whether it continues. And that's only relevant because it's in combination with the question of the existence and extent of any personal benefit conveyed as a result of the relationship.
All right. So, like I said, did he convey anything to her? Did he give her anything in over the course of this relationship? She's saying it started in 2022, it's 2024, so that's at least 2 years. The defense is saying it started earlier, prior to him coming on as a co-prosecutor in this case. So that part doesn't matter, but at the point that she hired him, it would matter. Okay, so let's keep going.
That being said, I don't think that means that everything that has been raised in the defendant's motions, and Mr. Roman's or in the ones adopted by co-counsel, demand an evidentiary hearing. The testimony that would be produced at this hearing is not a deposition. It is still subject to the rules of evidence. And so I think the facts that are going to be developed on the record have to have some relevance and some materiality. Now, contradictions or how things play out could impact that, could change what is relevant. But at the outset, there are a few things that I don't think are. So to that end, I don't think the particulars of Mr. Wade's experience are relevant. I don't think those are material for an evidentiary hearing. His alleged lack of experience handling RICO cases or any inferences regarding the intent from that can be addressed at argument. Okay,
let me pause here. So one thing that the defendant and his counsel brought out was that Fani Willis hired Nathan Wade, but he had no experience with RICO cases. This was not his forte. So it does, beg to differ why she hired him as co-counsel when he didn't have the experience to handle a case of this magnitude. Now, the judge obviously is pushing back on that, and he's basically stated, once you've been barred and you're an attorney, then it really shouldn't matter. You should be able to handle any case. And they teach you that in law school anyway. You can always bring on counsel to help you out. So let's keep going.
But in my mind, as long as a lawyer has a heartbeat and a bar card, that lawyer's appointment standing alone is a matter within the district attorney's discretion.
Did you get that? So as long as he's an attorney, she can bring him on.
Similarly, I haven't found a reason to find that the regulations or the alleged violations of Fulton County code are relevant in and of themselves. I think the violations of these rules can be argued as a matter of law if council wish to do that. But I've yet to see case law or anything indicating that these violations, if they did occur, are relevant to disqualification or a pending criminal case.
Now, I don't know what the Fulton County rules are that he's speaking about here, but he's saying that he did not really see, he doesn't see anything indicating that there was a violation. I don't know what he's talking about per se. I would need to see that read this complaint to see what the defendant put in there. But I think that's important because he did mention something about whether or not relevant to the disqualification or a pending criminal case. Did you guys get that? You start paying attention, guys. Relevant to a disqualification or a pending criminal case. And then finally, the motions or whatever. So you just have to see, like, this disqualification has so many legs, and it could just go in a place where Fani did not expect it to go. And she should have been prepared when she brought him on, because she should have known that they were going to uncover every stone, turn over every stone to find out anything they could on her to disqualify her. Let me keep going.
And then finally, the motions have also evolved to include forensic misconduct on behalf of the district attorney. And again, I don't see how these are a necessary topic for an evidentiary hearing unless it's made an issue in some way. The public statements, in my mind, speak for themselves, and the application of the law to those statements can be argued, and I don't think any further testimony qualifying them is going to affect the analysis. So with that.
So this is interesting on the forensic misconduct, because there are co-staffers from that DA office that are now they're like whistleblowers that are coming out now, speaking out against Fani and saying that she misused funds. So this is going to be interesting going forward. Let me keep going. But he's saying that's not important in terms of this. What's important in terms of this hearing is whether or not she benefited from the relationship and when this relationship started. That's what he's looking at, not the misuse of the funds.
That being said, I'll turn it over, Ms. Merchant, to you just at the outset. If you have anything you want to preserve for the record or to reply on, and then from there we can take up the motions one by one.
No, Judge, we appreciate that, narrowing the issues, and we can on.
Okay, I'm going to pause and go down to the part I think is important that she talks about. She's thanking the judge for narrowing the issues that he's going to address during that hearing. Okay, so let's take a look. Let's see. All right, let's start here. Okay, let's start 17 minutes, 52 seconds.
In an affidavit, what you want to talk about, and there's no cross-examination. So that is not, it's not admissible. We put that in our brief. We've argued that it's just not admissible. It's not relevant. It's hearsay. Nothing more than hearsay. We have a right to make a record on these allegations. And as long as we keep our evidence and our questions narrowly tailored to that inquiry, that is our right. We have a right to explore whether or not there was a personal or financial benefit to Miss Willis from this relationship. And we have carefully chosen the witnesses that we have subpoenaed based on that. And I just want to walk through a couple of them. But before I do, before I move on the affidavit issue, Mr. Wade has filed other affidavits in his divorce case, which contradict this affidavit. His interrogatories, which were sworn and verified and filed in that case, said that he did not have a personal relationship. That there.
Again, I'm like, is this amateur hour? The divorce interrogatories versus what the affidavit for this case states. Two contradictory statements. I don't know what Fani and Nathan are doing here, but they need to get their story straight.
There had been none. So we've got two declarations in two different courts, both sworn, both filed with the court, that say something completely different. His May 2023 affidavit, where he was asked if he had, and this was in 2023, Judge. So the state's response last week said they had a relationship that began in 2022. In May of 2023, he filed in the Cobb County Superior Court a pleading that said specifically if he had had any relations with a person other than his spouse during the course of the marriage, you know, and the typical things that are asked in a divorce case, and he responded none.
I mean, I get it. Nobody wants to say they've been cheating on their spouse, but they've let the cat out the bag that he had. Okay, let me continue.
After we filed our motion in this case, he updated those and he pled privilege under the Fifth Amendment. So we've got a filing under oath by Mr. Wade in 2023 stating he didn't have a relationship. Then we've got a filing stating he did have one starting in 2022. And then once that came about, he fixes the incorrect affidavit that was filed back in 2023.
Okay, so he went back and changed the affidavit that he filed in his divorce. This is messy.
So we definitely have a conflict, Judge, in the evidence as far as when this relationship started. I mean, just from the hearsay affidavits, we've got a conflict, Judge. There's also some other things in the Wade affidavit that we have conflicts in. We've got the date. We've got whether or not they cohabitated, whether or not there were any funds that he was paid that he used for travel with Miss Willis. We have quite a few documentations that we have attached to filings, and we have more that we intend to present.
See, this is what I was saying. If you know, it could be something simple, like, I don't know, I took you out for drinks, or we stayed at this hotel, you know, or I don't know, I took you on a trip to the Bahamas, I paid for it. Just simple things that you typically do in a relationship. But this could give an appearance that she benefited, you know, and it just, the question is, when did this relationship start? Because then it would be a conflict of interest if all of this occur, if this relationship was going on prior to him being brought on to assist with this Trump case. Let me keep going.
At the hearing in this case, to show that she did receive a lot of benefit, a lot of financial benefit in the forms of different trips, plane tickets, hotel rooms, Ubers.
Yep, just as I said.
Things like that. We have all of those from the financial records, which I'll go into in just a minute to stay on task. Go into those in just a minute. But that's as far as Wade. Why we think that Wade definitely should be called as a witness in this case. How can Mr. Wade not have relevant information to this inquiry? That is the real question here. He probably has the most relevant information to this inquiry. Same as Ms. Willis. She probably has the most relevant information to this inquiry. Mr. Bradley, the state has taken it upon themselves to file a motion to quash Mr. Bradley's subpoena. Mr. Bradley has not filed a motion to quash. The divorce in this case was not filed until November 2021. The only privilege that can be asserted is things that were said in furtherance of legal advice. So if Mr. Wade made statements or comments to Mr. Bradley in furtherance of legal advice, we're not going into any of that. We don't have any intention of getting into a privilege dispute, what was privileged and what was not. The relevant information that Mr. Bradley has to this inquiry is that this relationship started prior to Mr. Wade being appointed as a special prosecutor in this case. He has firsthand knowledge that this relationship predated that. He has knowledge, and not privileged knowledge, Judge. The divorce action hadn't even been filed at that point. He has personal knowledge, not privileged knowledge, that they had cohabitated, had stayed at the same place. And, you know, I certainly don't intend on getting into an argument over what the term cohabitated means. They had stayed together. That
was going to be my question. Did he move out and move with her, or did, like, I don't know, he was spending the night with her here and there? Because that was going to be my next question. What cohabitated in what context?
Mr. Wade had stayed at places that Fulton County was paying for Miss Willis to stay at. He's got information about that. We have outlined all that. We've made a
So basically he was spending the night with her here and there.
proffer. That is not privileged information, Judge.
And unlike some of the, I guess, other witnesses that are here, challenging their subpoenas. My inference from the supplemental reply is that this is something that you have corresponded or communicated with Mr. Bradley about directly.
Yes, only non-privileged information. Yes, Judge.
All right. And
Okay, I'm going to stop right there, guys. This saga is going to be one for the records. I mean, it's already sounding like chaos in the Trump RICO trial with the prosecutors. I mean, the trial can't go on until this whole issue of whether or not Fani is able to continue or whether or not she's going to be disqualified. Another prosecutor has to, take her place. They have to get up to speed. This is really going to be, this is one for the history books. So I guess you guys let me know what you think in the comments. Do you think Fani is going to be disqualified? Let us know. We'll be tracking this. We'll see what Friday brings as the judge kicks off this hearing. We'll see whether or not Fani and Nathan are actually subpoenaed. And also, not only just subpoenaed because they have been subpoenaed, but actually if they actually testify at this hearing. And we will see exactly what this former co-employee of Nathan states at this hearing as to whether or not this relationship actually started prior, this Mr. Bradley, if this relationship actually started prior to Nathan being brought on as a co-prosecutor. So, all right, guys, that's it for today, and we'll talk to you soon. All right, have a good one. Oh, you know what? Before I go, if you like what you're receiving here, please like and subscribe. It helps our channel grow. And we look forward to bringing you more celebrity legal news. All right, have a good one.